I'm actually in my 51st year at a law firm, now very casually as a consultant, but for the vast majority of that time, as a solicitor, I acted for patients because the defence side wouldn't have me. The last 20 years, I've been qualified, over 20 years, I've been qualified as a mediator, and as you've heard, I've conducted around 350 mediations, the vast majority of which have been claims by patients against doctors of various kinds, where I'm the independent neutral. And the company I'm a director of has had since 2017 one of the contracts from NHS Resolution to supply mediators to mediate clinical negligence and personal injury cases brought against NHS trusts and in recent years NHS-backed GPs. I thought that I would start with a pop song lyrics. For those of you who are nearer my generation, from around about, I guess, 1980, 1981, where there was a group called Bananarama. And they got together with another group called Fun Boys 3. And the lyrics, which I have shortened and I will definitely not sing to you, say, "It ain't what you do, it's the way that you do it, and that's what gets results. It ain't what you do, it's the time that you do it, and that's what gets results. It ain't what you do, it's the place that you do it, and that's what gets results." And for some unknown reason, when I started thinking about what I would say today, it seemed to me that those lyrics, which suddenly sprang into my mind, pretty much summarise the core of what I want to try and get over to you, that comes from my experience both as a claims lawyer and having the great privilege of being in both rooms in a mediation. So creating the right atmosphere, dealing with extrajudicial remedies, which are a key part of the NHS Resolution mediation scheme, seems to me to be the prime driver for any discussion about the duty of candour and the effective apologies. And I start with not the 2018 behaviour report investigation that NHS Resolution did, but because I'm old, I go back to 2001, where an academic called Mulcahy summarised the shopping list that claimants had when bringing a complaint. And why that was looked at was because at that time was the first national audit inquiry into complaints. And I was asked to appear in front of that inquiry when it was doing its research. And it became evident to me immediately that the inquiry team had not understood at that stage, an early stage, I suspect, in their inquiry, the distinction between a complaint and a claim, and the relationship between complaint and claim, which Naomi Lafferty has just alluded to, because there is a considerable amount of research, and I'm doing this off the top of my head, starting with Harvard University, back at around that time, which demonstrated that if you recorded all your adverse incidents and then looked at the percentage of incidents that led to claims, even in an adversarial and litigious society such as America, it was a very, very tiny percentage. And that if you fought it off very early on by being honest and make apologies, that percentage dropped alarmingly. Or, put it the other way, dropped in a very positive way for the parties involved. So, putting the lawyers out of business, if you like. And I have a dim and distant recollection that I think it was at Teesside or Tyneside NHS trust, possibly having read that kind of report analysis, adopted a policy of saying sorry. And their statistics at around that time showed a total fall-off of claims. So being honest and creating the right atmosphere very early on with a dissatisfied patient where things may have gone wrong is, in my view, extremely important. So far as the lawyers are concerned, I've lived through the era which started when cases were bought without exchange of often medical records. I was the one that brought the case to a county court judge, trying to get medical records before an inquest, a case called Stobart. And that was before the Access to Health Records Act, before the Data Protection Act. And then the health authority policy was they would supply the records 14 days after the conclusion of an inquest. And I fought that policy and won the application. It was no longer required when the Access to Health Records Act came in. But that was the kind of position we were in. My first ever trial is ingrained in my memory. It was in one of these Victorian courts where we, the lawyers, with the clients, were sitting right down in the well, and the judge was way up there, and the witness box was way up there. And I was acting for the parents of a child that died of Hirschsprung's disease. Hirschsprung's disease is, I recollect, a bowel disorder, which, if left untreated, can have fatal results for children. In that case, was left untreated, and that was the nature of the case. Believe it or not, for you youngsters, in those days, you did not exchange witness statements. You did not exchange experts' reports. So you turn up at court knowing very little about each other's case other than what was in the pleadings. And the first offence witness came into the witness box. He was the consultant in charge of the ward, and he picked up the Bible, he took the oath, and then he turned to my client in the well of the court and said, "I'm terribly sorry. I've ruined these parents' lives." And the mother turned to me then and there and said that if only he'd said that to us at the time, we wouldn't be here. There was legal aid in those days. The value of a child's life was £3,500. After the trial, we won on breach of duty and lost on causation, the judge ruling that the child would have died anyway. But what a waste of time and money. He'd not gone near them. He was old school, he didn't keep any records, and he'd not gone near the parents until that moment in court. And that was just ingrained on my mind, and still is. The second incident from my early days in practice that's ingrained in my mind was when I acted for a lovely old lady who was on a ward, a day surgery ward. And the surgeon who was doing the little operations, the minor operations ward, got the order wrong and gave her an operation on her thumb instead of her little finger. And he realised that very, very quickly. He apologised to her at the time. It was the days before you had typewritten medical records. But amazingly, when I got those records, there was a beautiful typewritten note that he'd given that apology. So I asked the client, as I always would, but why do you want to take this further? What's the driver? What are you looking for? And she said, "Paul, he did apologise to me, but I never saw him again. I had to stay in hospital longer. I was in a lot of pain, I was put in a bed at the end of the ward, and no one came near me. I was in there for 2 days. No one spoke to me. The doctors ignored me. The nurses seemed embarrassed. And I just wanted to be heard and for something to be done to stop it happening to others. So I've come to see you. So, without being frank from the outset, nowadays core duty of candour, there have always been far more claims brought that could have been nipped in the bud, and greater cooperation and understanding from parents, relatives or patients. So it ain't what you do, it's the way that you do it is really important. It's what you say as well that is very important. So I, as mediator, have seen the increased use of letters of apology. And some of them are terrible. They're terrible in their wording, they're terrible in their timing, and they're terrible in their format. And there does seem to me to be a total lack of understanding of what should be contained in an apology letter. Now, I've given this kind of talk or discussion at my old firm, well, I suppose it's still my current firm, technically, when I'm training the youngsters, well, they're all youngsters. Quite often the response is, but these days what we do is we contact Ian and his colleagues, and if there is going to be a letter of apology, quite often we're supplied with a draft. And we work together in a collaborative way to make sure that it fulfills as much of the requirements of the patients as possible. And the same happens in a mediation. I'm a mediator. We're dealing with extrajudicial remedies. I have no power as a mediator, but I really encourage the parties to deal with that first on the mediation day. I have defendants sometimes say to me, Paul, let's just get on with dealing with the case. We'll deal with all the other matters at the end, and it doesn't work. By the end, win or lose, settle, not settle, the claimant's had enough, tired, weary, and you've missed the opportunity of creating the right atmosphere to start with. But I've seen letters of apology arrive the night before a mediation, and that really upsets patients. Why have they left it so long? Why have they done this on the day or the night before? We haven't slept all night. Sometimes the apology is worded in such a way as to upset them. I've had claimants walk out of a mediation because of that first thing, and had to try and work very hard to get them back into the room. I've seen letters of apology signed by a chief executive, and I know it's a chief executive because it says chief executive at the bottom, but his signature is indecipherable. His name isn't anywhere on it. Anyone could have written that letter and signed it. And you might think it's just a little thing, but to people who are emotionally charged, who are, if you like, trauma victims, I'm going to come back to that in a minute, things like that have significance that if someone took a step back would realise is fully justified. So to coin or to adopt the phrase used by NHS resolution itself, in fact I think the patient safety team, say sorry meaningfully. And saying sorry meaningfully includes the way you do it, the format you do it. And saying sorry doesn't actually have necessarily to relate to everything that's in dispute in a legal case. So I'll give you an example. I mediated not so long ago, face-to-face, in a barrister's chamber in London, a case brought by relatives of a deceased patient of a now retired GP. It's very seldom that a defendant in person, if you like, is there with the lawyers. So it wasn't unexpected that the GP was there. But the GP was retired and turned out to have emigrated to Australia. But at the start of the mediation, I had tried and failed to persuade the claimant to have a meeting, the claimant's relatives, to have a meeting with the defence team. I have no power to order anything. I always like to start that way, just to introduce everybody, but they didn't want to. What happened was, when I went to see the defendant team, they had come along with a letter that the named defendant, the retired GP living in Australia, asked them to give to the relatives. So I took the letter and gave it to the relatives. And the letter simply said, I'm really sorry that you brought a claim. Whatever happens today, I wish there's a satisfactory resolution. I'll be thinking of you. I've enjoyed being your GP for the 20 or your relative's GP for the 20 or 30, last 20 or 30 years. I'm now retired. I'm living in Australia. I can't be with you. Had I been in England, I would have loved to have met you and talked to you. So that's not really a letter of apology. But that had huge significance, as it turned out, because at the end of the day, we did resolve the case. And the claimant's relatives asked me to arrange a meeting with the defence team. And they went in, met the defendant barrister, and they must have chatted away very amicably for at least half an hour. It was resolution for them. It was recognition for them. Yet that wasn't what you and I would describe as a letter of admission or even a letter of apology. And liability remained in dispute. The case was settled, but liability was never admitted. So again, an anecdotal illustration, because obviously as a mediator I can't go into details that reveal confidences from the mediation, but I can talk about the structure. And that seems to me to be a very fine learning point. And of course, if there is on the shopping list learning lessons, which there often is, Mr. Baylan, I'm only here because I want to make sure that the trust or the doctor has learned his lesson from this and no other relatives or patients will have to go through that. How do we deal with that? Well, in choreographing the mediation, in my pre-mediation calls to the parties' solicitors, I always try and establish, are there extrajudicial remedies sought by the claimant? If there are, have you discussed it with the defence team? If not, do you want me to discuss it with the defence team? I can't talk about to one party what I've discussed in the other room or the other call. If I'm released from that, I can. And usually we're able to choreograph with the defendant's team. If it's lessons learned, can someone from the trust be present? Perhaps someone from patient safety and learning. I can tell you as mediator, it's not the lawyers that are important to the claimant in the room. Virtually every single mediation I've had where a non-lawyer has turned up as well as the legal team, like the likes of Naomi, or even the NHS resolution case manager. the significance of them being there to a claimant's family is hugely important. So it's obvious to me, hugely important. So if there's apologies to be given, it's even more powerful coming from a non-lawyer. Some lawyers do it really well, but it's amazing the traction that the involvement of the non-lawyers give. And I've asked myself why that should be. And it seems to me the answer is this. When things go wrong, irrespective of whether there's fault, but when things go wrong and there's an unexpected outcome to the patient or the relatives, by and large, under our system, their lives are then taken over by people who tell them what to do. It can be experts, it can be coroners, it can be police, it can be the lawyers, it can be the barrister. So mediation is a fantastic forum where suddenly they're given a voice, they're given autonomy, and there is a reason, I expect, why what I used to call NHS Litigation Authority changed its name to NHS Resolution. Because resolution is what it seems to me this is all about. Other people have taken over their lives, but if their voice is heard and real people, lawyers aren't real people, you understand, empathise with them, it's amazing the impact. I'll give you two illustrations. Face-to-face mediation, and the defendant team turned up with the clinical director from the trust. And I was introduced to him in the privacy of their room. And he said, Paul, I'd really like to meet the claimant. So I said, fine, I have no power to get the claimant to agree to that, but I will do my best. He said, it will mean an awful lot to me. I said, oh. He said, I'm here as clinical director, but in fact, I was the duty surgeon who saved her life when my colleague ran into trouble in the operating theatre. I'd really like to meet him. So I went into the claimant room and I said, the trust are represented by and the clinical director is here. And the clinical director very much wishes to meet you. Why don't we have an opening session for everyone to introduce themselves? And she said, I don't really want to meet anybody from the trust. I said, well, that's your prerogative. I said, what happens if I just arrange for you to meet the clinical director who's here and who's expressed a wish to meet you? I said, my understanding is he was the surgeon who saved your life. And she said, I'm very scared. So I said, I tell you what, I'll come with you, I'll hold your hand. I'll arrange for him to be in a separate room. There'll be no lawyers there apart from myself. I happen to be a lawyer, but I'm the mediator. Nothing will happen. He just wants to meet you. So she said, okay. So I took her by the hand, took her into the private room where I put the chief executive. We walked through the door, and they fell into each other's arms and both burst into tears. What happened in the mediation settled subsequently very quickly, but that was irrelevant. It brought closure for both sides and was by far and away the most significant thing that happened in that case. The other illustration is at the opening session. my practice, which has evolved over the years, is very seldom do we have a formal opening session like we're trained as mediators to do, where both sides set out their case. That doesn't work in NHS cases. There's no reason for it to work, because usually there's professionals on both sides, professional lawyers on both sides. The documents speak for themselves. There's no point in having a trial opening statement, as it were. Furthermore, we as mediators these days encourage the use of position statements, so parties can set out their thoughts as to resolution. So a position statement isn't a case summary, it's not a pleading, it's thoughts on resolution. But an introductory session is a natural human relationship building setup. Put everybody in a room or online on the same screen. I'm Bloggs, I'm barrister for the claimant. I'm Bloggs, I'm barrister for the defendant. Everyone introduces themselves and so on. And it's a fantastic time to encourage the claimant to give an impact statement. And increasingly, claimants are prepared to do that. Some just refuse point blank. I'll come back to refusal in a minute. But any number of times, the statement, either read out or just given out by the claimant or the relative, has had a huge impact on everyone in the room. I've had cases where it's changed totally, for example, the defendant's perception. Because papers only go so far. The defendant team, until that stage, probably have never met the claimant. It's a name, she or he is a name or a number on a piece of paper. So when someone appears, I, like the defendant, because I get the papers the night, or read the papers the night before, I form a view of what I'm going to see. And it's amazing how a human being speaking can change the perception of what the wording in the documents, the formal documents, really mean. And that is really, really important. And I've had several instances where Naomi or her colleagues have been there, listened to what the claimant has had to say personally, and then approached the claimant and said, would you come to the trust or maybe elsewhere and talk to our doctors, because they will learn more from you than chalk or talk on a board. And I know you use Mrs. Montgomery, for example, in dealing with issues of consent. I am privileged enough to have met Mrs. Whittaker, who was the Australian lady in the case of Rogers and Whittaker. She was the claimant, but it was on appeal, so that's why her name comes second. That actually led to Montgomery, because it was a case where they said, yes, the patient's requirements must be met, not the doctor's requirements in giving consent. And she had agreed to undergo, she had a problem with one eye, she'd agreed to go for an operation on the other eye, and was not told that there was a risk of blindness. And she ended up with no eyes. And I actually met her, I was lecturing at a conference in Sydney, and she was there giving a talk on consent, surprisingly. And you can bet your bottom dollar that every single person in that room, still to today, remembers meeting the eyeless Mrs. Whittaker and had recognised what consent is all about. So empowering the claimant is extraordinarily important. So I've had my time no doubt, but I just want to end with, in case you don't believe my anecdote, after a mediation, we always ask the parties to give a reference. And that's not trust mediation, it's NHS resolution requirements. And we have to report, as you defence lawyers, they don't have to report to NHS resolution after mediation, not to reveal confidences, but what the parties think of the mediator, the mediation. I'm just going to read these comments. They are real, I haven't made them up. They appreciated the opening session discussion with the defendant before the day started, particularly as the trust explained what changes have been made at the trust since their father's death. I liked how the client was involved in the process and could give information directly to the mediator rather than talking through lawyers. The open approach of the defendant was also extremely beneficial, and the posturing that can sometimes occur at RTMs was avoided. My client was appreciative of the group session at the start of the day when they could ask their questions. The words expressed by the Trust's legal manager at the beginning went a long way with our clients, and although a financial settlement was not achieved, I believe both parties walked away with a clear understanding of where we are apart. The claim is very likely to settle in coming months, at least in part as a result of having gone through that process. I just wanted to thank you for all your help today. I'm very pleased with the outcome, and I know my client found the process beneficial as she was able to obtain justice for her son. It also provided her with a voice, and I know she felt better for speaking in the initial meeting. And finally, although emotionally tough, I think the family felt they achieved as much as they could in the morning, and they were relieved to conclude the claim for compensation in the afternoon. I'm grateful for the part you played in both elements.
Thank you. Thank you. Thank you.